So first I want to say I hope everyone is healthy and keeping safe. This topic on the Secure Act, on basically dealing with retirement plans, IRAs, qualified plans inside of your estate plan, is a major issue, and it was huge. As of December 20th, it came out of nowhere. It had been discussed in the summer of last year and disappeared, and then came about. Let's see. Allison, if you can see, there's a couple of people waiting. I don't think it's automatic for some reason. Let's see. Admit all. All right, I'm gonna keep trying to do this. Sorry. This is our first webinar, so a little bit of not perfect, but we're gonna keep going. All right, so in December 20th, we ended up with this crazy law that radically changed the taxation of IRAs and qualified plans. And it started about 2 weeks later, on January 1. And the major problem wasn't the taxation aspect. The major problem was how we dealt with IRAs and qualified plans inside of your estate plan. And it radically changed the whole analysis of how we deal with it, which caused almost every single one of our clients, almost every single person in the country, to have to think about what they were doing in their estate plan with their IRAs and qualified plans, and potentially had to change how they dealt with it. That's a big deal. So we spent, I know I've spent over 100 hours on this, written several newsletters that y'all have probably seen or come across your email. Been on the circuit speaking about this. The last speech was a modification of this speech to the Atlanta Bar estate plan probate section, which was a couple weeks ago, maybe 2-3 weeks ago, on this topic. My hope is this is my last speech on this topic, because I've given quite a few of them. The goal of this one is really to get to the self-assessment tool. The thought was that since every single one of our clients, and if any of the advisors are on here, any of your clients, they all need to consider this issue. And so it's really difficult for lawyers to go back and look at every single client they've ever had to see what should happen. At least they want to stay in business. And clients usually don't want to pay for the lawyers to just go back and check their stuff all the time. So my thought was, let's come up with a self-assessment tool so that the clients or their advisors can go through the analysis and at least come up with a general, I'm all good, no worries, or no, we need to make a change, or at least consider making a change. And then you need to come in, talk to the lawyer about, okay, here's where we're at, what should we do? Now let's go through the analysis in more detail. So you'll see on the screen, this is our PowerPoint. I didn't know how to use PowerPoint until a few weeks ago when I made the first slide presentation I've ever done for the Atlanta Bar presentation. All right, so here we go. Let's move this out of the way. All right. All right, so what did the Secure Act do? First, I'm gonna go through a little bit of just general stuff, and we're gonna try to hit really hard the real substance of what we're trying to get to. The Secure Act changed the required minimum distribution rules. So what are the required minimum distribution rules? They say the government wants you, they encourage you to save for retirement, and so they make it really worth your while. Except for Roth IRAs, all other retirement plans, IRAs, you get a tax deduction on the way in, no tax during the time the assets are in the plan, and then there's no tax till it comes out. Roth is a little bit backwards. You pay tax on it's not after-tax assets on the way in and no tax on the way out. But the government's position is we need our money. And so since we need our money at some point, they wait for you to retire, at least general retirement age. And they say, now we're going to force the property out so that we can get our tax money. And so when is that? And these rules for the owner have not changed. They're excellent rules. I've seen these rules for over several decades. These are exceptional rules. And they basically say when you hit age, used to be 70.5, now it's age 72. In that year, you start to get out the required minimum distribution based on the joint life expectancy of yourself and someone 10 years younger. It's really a joint life expectancy chart. The IRS gives you the chart. You say, what was the balance of my account on December 31 or January 1 of the next year, that January 1 of that year, December 31st, that number, and you take the chart and say you put your age in, it tells you a little factor, multiply the factor by that account, and that's what you take out. The first year you start, you can actually postpone the first distribution till March of the year after you turn 70, now 72, it was 70 and a half. Those rules are good. No complaints whatsoever. The Secure Act only made them better because you don't have to start at 70 and a half, you start at 72. That's all good. When you go to the spouse, it's all good. There's a little tweaking difference under the Act, but very minor, and it only relates to marital trust. Other than that, it all works. The spouse is in a great position. If you pay all, if the beneficiary is all outright to spouse, spouse has the power to roll the amount over into their own name. So now it becomes your own IRA account with their own joint life expectancy rule, just like they're the owner. Or they can choose not to roll it over and they're like the other beneficiaries, but they're given some special status. So that's all good. That's all good. I had no complaints. The issues come in on non-owner, non-spouse of owner beneficiaries after someone dies. So what happened? They changed the required minimum distribution rule, the period of time over which the beneficiary can take the property over, from life expectancy. Hang on one second, sorry. Sorry about that. My wife is in here in another meeting. I can actually hear it going back there. So sorry about that. All right. So you can, it used to be life expectancy, which was really good. And we called it a stretch IRA. That was just a general wording of it. And the reason called stretch IRA is that the beneficiary could stretch out over their life expectancy, taking a little bit out each year. So effectively, it was like their own IRA with a slow leak, because it was over a long period of time and they're still earning assets, and so it can last a long time. That was all great. But under the Secure Act, they wanted to change some other rules. They need to raise funds. So how do you raise funds? They took the life expectancy rule and took it back to 10 years for most beneficiaries. So the requirement minimum distribution rules were modified from 7.5 to 72. And then from most beneficiaries that are not spouses, went from life expectancy to 10 years. For some, called eligible designated beneficiaries, we still have life expectancy, kind of, and we'll go over that, but that's the minority of situations. So why is this such a big deal? Okay, so it made taxation for beneficiaries of deceased owners, it made it a little faster. And I would say, well, that's life. Tax laws change all the time. I've been doing this since 1987. The tax laws have changed many, many, many times. I can get over that. I don't like it, I get over it. That's not the problem. The problem is how we dealt with retirement plans and IRAs inside the estate plan. And it comes down to when you have trusts for your beneficiaries. So if you have the assets passing down in trust for your children, when it goes into trust, we had to take certain positions, and we'll go over what those positions were. What I can tell you is position that the mass majority of people use as the fallback in the mass majority of cases doesn't make sense anymore in a lot of cases, the way the rules work. So it wasn't necessarily the taxation aspects of it, it was how we dealt with it in the estate plans now has changed fairly radically. That's the biggest deal. All right, so why is this such a big deal? If you don't comply with the rules, there's a 50% penalty, and the penalty is annual. So you have to make sure you take a good position in your estate plan, and then you follow whatever it is, because if you don't, the penalties are just egregious. All right, let's go to the next one. All right, so what did the required minimum distribution rules, there's a definition of what they did. So there's required minimum distribution rules, basically have effectively the better rules are for beneficiaries who are considered designated beneficiaries. They are individuals and qualified trusts. There is also something called a non-designated beneficiary. That means they're not individual and not a qualified trust. And those rules have not changed at all. And we'll go through what that means. But the only rules that have changed are for designated beneficiaries, individuals and qualified trust. And they went from life expectancy to 10 years for most non-owner, non-spouse beneficiaries. All right, let's see what else we need. All right, who are the ones that get special treatment under these rules? So the designated beneficiary gets 10 years unless they are an eligible designated beneficiary. They still get life expectancy or some form of life expectancy. One, participant spouse. So that gets us back to where we were before. So the owner and their spouse are pretty much treated the same as they were before. So for married couples, for most people, they will usually have the asset, have the IRAs, qualified plans passed to their spouse. If you do that outright, the rules are the same as they were before, basically. If you go in trust to the spouse, a little bit different. The big issue is not the spouse, it's what happens if the spouse, if you're single or the spouse is not living when you pass away. So who are the eligible, who gets life expectancy still, other than the spouse? And that is someone who is about the same age as the participant being the owner. And who would that be? Someone who is not more than 10 years younger. So that would be parents, siblings, cousin, non-married life partners, friends, people about the same age, not more than 10 years younger. They still get life expectancy because it's about the same life expectancy as the participant had in the first place. They're trying not to get a long additional deferral period. So since it's about the same, they're like, okay, we'll give them life expectancy since it's about the same. Let's see. Oops. Here we go. Sorry about that. I keep having to admit people. All right. Next one is qualified, disabled, or chronically ill. This was the one change. They talked about this law in the summer of last year. And then when they re-brought up out of middle of nowhere, at the end of the year, they added one change. And that was basically to take care of the disabled and chronically ill, really for the most part for supplemental or special needs trusts, people that want to qualify, potentially qualify for government means tested benefits. And they came up with special rules about that, and life expectancy still happens, and it's a special rule we'll go over. So the spouse is the same, someone within 10 years, no more than 10 years younger is the same, and someone who's chronically disabled, chronically ill or disabled has special rules. The one that's an odd one is the participant's child. And there's several caveats about participant's child. So number one, even if it's a participant's child, it's limited until the child becomes the age of majority. So this would only be for people with young kids. So if the child is under age 18, then they get life expectancy. They die prematurely, which of course doesn't happen that often. But when it does, and they have young kids, the child gets life expectancy until the age of majority, which is at least state law age of majority, which is in Georgia age 18, in some states age 21, sometimes 19. In Georgia it's 18. And we get potential based on educational status, which no one understands what that means at this point, and I mean no one. You can potentially go up to age 26. At the point you get age majority, whether it's 18, 26, or something in between, it then switches to the normal 10-year rule. So that's one. It's only a temporary life expectancy, and then it gets 10 years as soon as you hit the age of majority. Number two, and this is, I keep forgetting this when I go over this, and my partner says, don't forget, because I forget it as well. And that is, it is only for the participant's child. It's not just a young person. It's not a grandchild. It's not a stepchild. It is only the participant's legal child, that's born or adopted child. So it kind of limits the benefits of doing it. It's not bad. It's better than nothing. It's just not as good as you think it might be. So those are the only special status. Everyone else gets the 10-year rule. That's a designated beneficiary, individual or a qualified trust. All right. So let's go over the first one, which is just an obvious thing that I want to bring out a point. If you were to give ask these retirement plans outright to a child, let's say a young child, and you died, and they weren't even 18 yet, can the child get it at age 18 and spend the whole thing? And the answer is yes. The required minimum distribution rules are not the, it's not a maximum. It's not it's a minimum that you've got to take out. It doesn't stop you from taking out more. You can take out whatever you want. Take the whole thing. Now, if you're a mature person, you're not going to take it all out. Why? You're going to pay tax on it. It's not smart at all. But a young person who hasn't been on the block before and isn't mature enough to understand finances may say, I need that nice new car. I need to go on this big trip, and I'll just gut the whole thing out and just pay the tax on it. I don't care. I don't know what taxes are. So going outright to someone is often not a good way to go. Also, from an asset protection perspective, we learned about 10, 12 years ago from the US Supreme Court that while an IRA is protected from your creditors as the owner, they can't touch it for the most part, I think up to $1 million each under bankruptcy law. That is not the case with a beneficiary of a deceased participant, which means a creditor can get to it if you go outright. So outright is simple. If you give it to someone outright, just name the beneficiary individual outright. It's simple, but it may, in a lot of cases, it's not the way to go. It doesn't have asset protection, and it gives them full control pretty much immediately. And if they're not 18, they'll get full control when they're 18 years old. So why would you, if you don't go outright, how would you go? You would go in trust. Why would you go in trust? Number one is control. The obvious one is the kids aren't old enough yet. The person you're giving to isn't old enough yet. We have to have a trustee control it on their behalf until they're mature enough to give it to them. Control can also mean all other kinds of things. Who's going to benefit over a long period of time? It can be very flexible. It can be very restrictive. You can decide who the trustee is, who's in charge to make the judgment calls. But a trust allows you to control as opposed to the beneficiary. Asset protection. This is the huge one when we go into something called long-term trusts. These trust shells protect from unwanted outsiders. No spouse in divorce, no personal guarantees, judgment creditors, no bankruptcy, nothing. No one gets in, no involuntarily unwanted outsiders can get in. And it can, to some extent, assuming your trustees, not the predator themselves, can protect you from predators. Even without legal ability to get in, they could talk you out of your money. If you have a good trustee, they won't be able to talk you out of your money. All right, so what are the kinds of trusts for required minimum distribution purposes, the RMD purposes? So this does not actually change the trust that you're creating. We're going to go over that in a minute. Is it a short-term trust, a long-term trust, a dynasty trust, whatever? We're not changing that. What this is inside of whatever the trust structure you're creating for your loved ones, how is it structured to be treated under these IRA taxation, qualified plan taxation rules? There are 3 types of trusts for RMD taxation purposes. Number 1, and this was the 95% answer before the Secure Act, before the January 1 of this year, this is what we used pretty much always. The only exception for us was when we physically could not force any distribution to the beneficiary. So what are the exceptions? Special needs beneficiaries. Someone's going to qualify for government benefits. We cannot force that. Someone who's disabled, mentally disabled, can't handle the funds. Someone who has dependency issues, drug kind of issues, things like that, that if we give them the funds, they could do bad things with it. Those were the exceptions. Everyone else in our practice got what we call conduit trusts. And when we did the Atlanta Bar webinar, we asked a question of the participants and said, what was your fallback? These are all the lawyers in Atlanta doing estate planning. What was your fallback? Half of them said outright. They just basically punted on the whole issue. And the other, and all the trusts, almost everyone said conduit trust. There may have been 1 or 2 exceptions, I don't remember. So this was the standard. What is the problem with conduit trust? This is what we had. Why am I making such a big deal about this? Conduit trusts, they have several requirements, but one that actually matters. And that one requirement says, so you have the trust and you have the IRA. And the trustee says, IRA custodian, give me the minimum distribution requirement of distribution based on that individual's life expectancy, or now 10 years or whatever it is. It used to be life expectancy. Trustee would give it to the trustee, and the trustee immediately had to shoot it out to the beneficiary. It could not be accumulated at all. When we had life expectancy, that was not a big deal. Why? Because it was a long life expectancy, and therefore the amount that was being forced out into the beneficiary's hands was relatively small. So basically, we didn't care. And so it was the right, as you'll see, the other answers aren't very good in relation. This is the only one where we can look through the trust to the beneficiary's life expectancy, as if the trust doesn't exist. The IRS basically says, we will look to the conduit beneficiary, the one that is getting forced the distributions out to that person, that we will look through the trust and treat that person as if they're the only beneficiary for RMD, required minimum distribution purposes. Everyone else will be considered mere potential successors, and the IRS terminology, they're ignored. Okay. The other kind of qualified trust, there's two kinds of qualified trust: conduit, see-through accumulation trust. And this is where all the confusion, frustration is from my perspective. The see-through accumulation trusts rules are what I would call nonsensical. They have requirements in them, and the requirements basically say as follows. If you do not have a conduit trust where it's forced out, the IRS position is that all possible beneficiaries must be considered. And there are two requirements to qualify. Number one, all, and I mean all, possible beneficiaries must be individuals. No charity, no estate, no creditors, nothing but individuals, which is an anti-charity kind of provision. Number two is the IRS needs to be able to figure out, the parties do and the IRS do, on the participant's date of death, who the oldest possible beneficiary could ever be. Now you got to think about that. Someone dies, we have to look in the future and say, well, if these people died, these people died, these people died, these people died, all the way until you get to the end. You have to say, who is the oldest possible beneficiary? There's one exception, totally nonsensical, and it says if you say if this person died and it goes to another person, and if the other person's alive, and it goes outright, no matter what, doesn't matter if they're disabled, it doesn't matter if they're 1 year old, doesn't matter. It goes outright to them. We will ignore the rest of the beneficiaries. Total nonsense. No one drafts that way, that does estate planning for a living well, put it that way. No one that would do estate planning properly would ever draft a provision that way. They would have provisions that would say, well, if an individual isn't old enough, isn't mature enough, is disabled, we'd have other provisions. Can't have it. Nonsense. So what does this mean? It means that if you use a see-through accumulation trust, it just means we have limitations on the terms. And that also means, because you have limitations on the terms of who can benefit and the flexibility provisions and the tax planning provisions that have to be modified, what we end up doing is setting up a separate trust share that holds nothing but retirement plan assets, with IRAs qualified plans, which increases a little bit of cost and hassle. So see-through accumulation trust might be the way to go, depending on the situation. It's just not the most pleasant thing to do. So there's two kinds of qualified trust. One is non-qualified. That is at the bottom, the non-DB trust, non-designated beneficiary trust. That has a whole different system. It has the fallback rules. So what are the fallback rules? If you qualified as a DB, the designated beneficiary, on the old rules, you got life expectancy, and on the new rules, you get 10 years. The non-DB trusts do not qualify. So that is totally separate set of rules. And what it says is that it depends on the age of the participant when they died. If the participant died before what is referred to as the required beginning date, there's a 5-year payout. If the participant died on or after the required beginning date, it is we'll call ghost life expectancy, and that is, you look to the participant's age, their life expectancy, as if they were still living. So you're basically getting either a 5-year rule if you died early, or if you died on the RBD or later, required beginning date or later, you get that person who's now deceased, their remaining life expectancy as if they were still living. So you either get under the new rule, you get the 10-year rule. If they're eligible designated beneficiary, you get potential life expectancy, as we talked about, or you get a non-DB trust, or it's a non-designated beneficiary. It's not an individual. It's not a qualified trust. You either get 5-year rule, or we call the ghost life expectancy, the life expectancy of this deceased person, as if they were still living. All right. That wackiness, we'll get that out of the way. So now we're going to go to the quick assessment tool. I need to give you a little bit of background so you knew what we were talking about. All right. So what are we talking about? Number one, we have 5 steps. They're not all actually steps, but I kind of set them out that way. Step number 1, determine if you need an estate plan review without the Secure Act considerations. So we'll go over all these in a second. This is just, hey, I need to come in, and remember the purpose of the Secure Act quick assessment tool, the self-assessment, is so that you can figure out, or your advisor can help you figure out, do you need assistance? Do you possibly need to change this? Because if you don't need to change it, then we're good. If you need to change it, you need to get some assistance. So do you need to come in regardless, okay? Even if without this consideration. And if you need to come in regardless, come in to us or their lawyer, and then you can go over this analysis when you come in. Number 2, and this is a key, everything comes back to this. Determine how you would like to pass your assets to your loved ones, whether it's the way you're doing it today or how you would like to do it. That is the key component of determining what you need to do, because that type of trust will help figure out everything else. Number 3, we go over some easy situations that are just easy, not a problem. 4, and this is where all the action is, we're using or would like to use long-term trust, dynasty trusts, or special needs trusts, simple needs trusts. The analysis is more complex, and you need to go at a case-by-case basis. If you're not using one of these, it's going to be under the step 3, a little bit simpler. And then step 5 is just some additional factors to analyze, and we go through that. And just so you know, we're going to provide you with these slides later, along with, you can watch this again if you want. We'll get you access to this webinar. We also have, I think, 3 newsletter type documents on our website. One is just about a Q&A. One is the self-assessment full discussion, which goes over in more detail, kind of like I'm doing now, but a little bit more, probably a lot more. And then we have the quick assessment tool that goes over this. So now let's go through it. And we'll try to get through as fast as we can, because I know this is kind of dense. All right. Do you need to come in anyway? And if you need to come in anyway, you can talk about the Secure Act stuff when you come in. Number 1, and this is the big deal, has it been at least 3 years since you came in? If it's been at least 3 years since you've come in, we recommend best practices to come in and review your plan about every 3 years. Why? 2 reasons. Number 1, you want to make sure that your financial power of attorney primarily, and to some extent your advanced directive for healthcare, are updated. Why? We want those as young and as fresh as we can get them. So when you actually need to use them, the third party, the financial institution, insurance company, government agency, will more easily accept it. The older the document gets, the more likely we'll have an issue of getting them to accept it. Also, if you haven't been in since the mid-2017, the financial power of attorney has totally changed, totally new law, and way more powerful. So it's been more than 3 years, coming anyway. The second is that you should, when you come in to do those things, review your plan just to make sure it's still what you want. Nothing be radical, but if you come in anyway, we can look at the Secure Act considerations as well. All right. Now, this is the big elephant in the room. How would you like to pass your assets to your loved ones? Whether it's in your current plan or it's in a potentially modified plan that you may do. Number one, outright. So it's outright, short-term trust, long-term trust, dynasty trusts, and special needs trusts. So outright, of course, is simple. I just hereby give outright to that person. To spouses, most of the time, not always, but most of the time now, probably in our practice, about 2/3 of the time, we're going outright to spouses. When it comes to, that's with all assets. Only about 1/3 do they go in trust to the spouse. And that's normally with situations where we have kids with prior marriages, or we have very large estates with tax issues. When it comes to IRAs and qualified plans, I would say it's 98% we go outright to the surviving spouse. Why? It's way better from an income tax perspective, and it is asset protected in the name of the spouse. So going to a spouse is a no-brainer. If you want to give to someone who's a non-descendant, not a kid, a friend, you're just probably not going to go out of your way a whole lot to do all kinds of protective, more complex trust structuring for someone like that. You'll just make it simple and just give it to them. When you have mature children, the answer is if it's not a lot of assets, then you might say, we'll just go ahead and give it to them. They're old enough to take it. There's not enough money to justify long-term trust or dynasty trust. Let's just give it to them, and that's normal. So that's outright. That's when you would do it. Short-term trust, that is primarily for children or other young beneficiaries when they're too young that you could trust so they could take care of the assets. So normally what happens is a trustee takes care of the assets until they get 25, 30, 35, whatever the ages are. We normally recommend installments over one lump sum so you can learn from their mistakes. So that's the standard, and there aren't enough assets to justify long-term trust or dynasty trust, and they're not a special needs beneficiary. So outright is simple. Short-term trust, we have the young kids and there is enough money or special needs to worry about, going a bit more complicated. Long-term trusts. So long-term trust in our practice, we think is phenomenal if you have enough assets to make it worthwhile. Long-term trust basically says it's equivalent of short-term trusts. So if the kids are too young to get it, it would be in trust. But at the point at which the child is old enough, if you want, the child can become their own trustee and just keep on rocking. But instead of getting it outright unprotected, it stays in the trust shell, in a protected trust shell, so that no one gets in. As long as the assets remain in trust, no unwanted outsiders get in. No divorcing spouses, no bankruptcy, personal guarantees, nothing. No one gets in but that child. If you decide, I want the protection, but I also want to protect the child from themselves, they get taken advantage of, I don't trust they'll do good things with the assets, then you don't need to make the child their own trustee. You have a third-party trustee and just keep the trust rocking, and the other trustee will take care of your child for the rest of their life, and eventually goes down to the grandkids. Also with these kinds of trusts, we give, and there's one difference between long-term trust and dynasty trust, which would be the next one. The issue is, when does it end? The long-term trust was the standard way we did it under what was called the rule against perpetuities. The rule against perpetuities is the state law rule we got from England. We got our laws way back when. It basically is a time limit on how long a trust can last. That law, it's a funky rule, but we had a safe harbor rule that was basically 90 years. 90 years from when you started would normally get you sometime at the grandchild level. And instead of paying it out ad hoc, depending on when the 90-year ran out, most lawyers did it systematically. The most common in our practice would be half of 30, maybe 35, something like that. It could be extended by the child through a limited power of appointment, but only for that 90-year period. On July 1, 2018, that changed radically under state law, the Georgia law. That 90-year rule is now 360 years, which means under the long-term trust theory, it would go out, pay out installments, but would give your child the power to extend through what's called limited power of appointment, and they could extend up to 360 years. Now, reality, it'll never get 360 years. It'll run out before that, but at least it'll run until the assets run out or they don't want it anymore. So that's long-term trust. It's protected as long as you keep it in trust, and we can make it really flexible or restrictive, and it's up to you to make that determination with your lawyer's assistance. The dynasty trust is the same as long-term trust. The difference is, instead of requiring your child to go to their lawyer to put a provision in their will to extend the trust beyond installments for the grandkids, dynasty trust is our name for when it happens automatically. It just keeps on a-rocking until the rule gets for the first to happen of, the rule gets perpetuities, 360 years, or the trust just run out. You gut them, there's not enough assets left, and just run it out. So basically, as long as the trust makes sense, we continue. They don't make sense anymore, they go away. The last one is special or supplemental needs trust, and that is exclusively for individual beneficiaries who either are or you have a higher risk of becoming special needs, disabled, where they cannot earn a living and need assistance. And they may be able to obtain means-tested government benefits. In order to get means-tested government benefits, you have to be poor on paper. The goal of these trusts is that these assets are available to aid and assist your beneficiary, but will not count for purposes of government means-tested benefits. So it won't blow their benefits. So those are all the estate planning options. So you go through that and say, that's what I want. Now we have to learn how to deal with it under the required minimum distribution rules. So now let's go to the easy situations. Number one, outright. If it's all outright, you're good to go. You're good to go. The rules work fine. You get your 10-year rule. And oh, by the way, I forgot to tell you this. Under the life expectancy rule, you take out, under the old rule and for the eligible designated beneficiaries life expectancy rule, you actually take out an amount every single year based on that life expectancy. With the 10-year rule, the new 10-year rule for designated beneficiaries, and the 5-year rule for non-designated beneficiaries, if you don't qualify and you die before the required beginning date, so that 10-year, 5-year rule, we call them, or I call them, a cliff rule. Nothing is required to be distributed until the December 31st of that 10th anniversary, the 10-year rule, on the 5-year rule, the 5th anniversary. So if you died on August 1st, you'd count 5 more years, go to December 31st. It's all got to come out by that 5th anniversary, December 31st, or you get 50% penalty, which would be really, really destructive. All right, so if we go outright, the only requirement is that you have it on your change of beneficiary form and you have it with your custodian or the trustee of the plan, the IRA custodian, the way you want it. Other than that, you're good to go. All the rules work fine. Short-term trusts. The conduit trust planning for short-term trust is highly likely the way to go because they're already going to be distributed anyway within a relatively short period of time. Well, let me back up. If it's your child, it's a no-brainer. Because if it's your child, you get the life expectancy until at least age 18, maybe 26 or something in between based on education. And then you get 10 more years. So in a minimum, the trustee can control it till age 18. I'm sorry, age 28, maybe to age 36. And if your distributions are 25, 30, 35 or whatever, you're pretty close. And remember, these are not all the assets, it's just the IRA's qualified plans. So with children, conduit trusts, no brainer with short-term trust. If that may or may not be the case, if it's a young beneficiary, that's not the child. Because a young beneficiary is not a child, doesn't get life expectancy. They're not an eligible designated beneficiary. They get the 10-year rule from whatever age they are. So if they're age 2, get 10 years, that means it all has to come out by age 12. Then it's in a custodial account until age 18, and then the beneficiary gets it all at age 18, can blow it all. It's a really bad answer. So if it's your child, conduit trust theory is beautiful. If it's not a child and they're really young, it may not be a good way to go. It may be if they're older, but not if they're really young. If they're older individuals, but they haven't quite hit those ages yet, conduit trusts are fine. Why? Because that 10 years would get them beyond, either at or beyond the normal short-term distribution ages anyway. So these are relatively simple, outright no-brainer, short-term trust, kids, conduit, older kids, conduit, beneficiaries who are really young that aren't your children, you may have to think twice about it. All right, so this is the crazy one. All right. So this is where you use long-term trust, dynasty trust, or special needs trusts. So what do? You basically look, and this chart I think is really, really helpful. You basically look at the situation, the pros and cons of each option in your particular situation. And I am not telling you that you should go through this analysis. If you get to this point, the right answer is probably you need assistance, or your other advisors can go through this analysis with you. You can try, no problem. It does take some thinking and some analysis. You have to actually want to do the analysis, or just come in for a visit and we'll help you go through it. All right, so let's go through them. The conduit trusts. So remember, these are long-term trusts. They're going to last a long time. Dynasty trust lasts even longer. And supplemental needs trust, we cannot require any distributions under a conduit trust for special needs individuals, because that would be horrible. That's just a bad answer from the estate planning perspective. So conduit trust, the beneficiary, the eligible designated beneficiary. With the conduit trust, you look through the trust to the individual's identification. So whatever the conduit beneficiary is, that's what you look to. If it's an individual, it's a designated beneficiary. If it's an eligible designated beneficiary, then they get the life expectancy. You get to look through the trust, and that may be a really good answer in your situation, depending. What are the pros? You get this, whatever the standard is, the 10-year, the life expectancy, whatever the standard is, the required minimum distribution, you get it. There's no special rule, you just get it. The only restriction is that you have to make distributions immediately out. And if that's not a problem, we're good. It is the simplest way to go. It is very simple, low hassle, low cost. The only thing simpler is outright, and outright oftentimes is not the right answer. What are the cons? You lose the benefits of the trust within that distribution period, which is normally 10 years. So you're going to lose the benefit, the control and the asset protection benefits. So if you have long-term trusts, you are blowing the benefit. And if this is a significant part of your wealth, you are making unprotected a lot of your wealth. And so you're not getting the full benefit out of your estate plan to the detriment of your kids or whoever the beneficiaries are. So that's conduit trust. See-through accumulation trusts, there's one exception. You do not look through see-through accumulation trusts. These are, you don't have to conduit, you have to pay out. See-through accumulation, you do not have to pay out. You can accumulate. So the IRA puts assets into the trust. You can accumulate inside the trust, and it's up to the trustee to determine when the distributions are made based on the needs of the beneficiary. There's one exception. This was the one that was added for the Secure Act right at the end of December, and that was for the disabled or chronically ill, and they're qualified as such as of the date of the participant's death. So someone that you think, because you're not dead yet, you have to plan for the future. Someone you think already is disabled or chronically ill, or you think has a higher risk, this is the way you're going to go. This is where your special needs trusts are going to be. And if they aren't, and they don't end up as disabled or chronically ill as of the date of death, it is what it is. You can't force out distributions anyway. So it's going to be the right way to go in most cases in that situation. What are the pros of a see-through accumulation trust? One, you get the standard period. You don't get the eligible designated beneficiary period. You get the normal DB period, which is, the 10-year period. The only ED, the only eligible is the chronically ill or disabled. And there's special terms you have to make that work. You have to be the sole beneficiary and some other stuff. The big one is you can accumulate planned distributions. That's the big one. What's the negative? This is where all the action is. It's not good. We can deal with it. It's just not good. And I said the way we deal with it is we normally create a separate trust that does nothing but hold these kinds of assets. So it can be more limited than your other trust share for the same beneficiary that can be more flexible and beneficial. You have to limit the term so a charity cannot benefit. And this comes in with contingent beneficiaries. If all your desired beneficiaries are deceased, where do the assets go? Probably not going to happen, but it could. We need something that adjusts. There's only two things that adjust because we don't know who will be alive in the future when this happens, if it ever does happen. Number one, heirs. Closest living relatives determined under Georgia law, and that works fine. And as long as you are okay with close family, we're good. Number two is charity, because if this charity that you chose isn't qualified, we can appoint a similar type charity who can step into their shoes, who is qualified. If you go with this type of trust, you cannot benefit charity at all. So you'll have to have a separate trust share, and in that separate trust share, it cannot benefit charity at all. We also have limited powers of appointments and general powers of appointments that we use for flexibility purposes and tax planning benefits. We can have some of it, and a lot of it is limited. So it just limits the beneficial terms of the trust. And again, the way we get around it is separate trust with all these limits, and the other assets hopefully don't have to have the same limits. While these trusts, any amounts that accumulated in trust do have some higher income tax rates today. This is not always the case, but today there's higher income tax rates if the funds are retained in the trust and not distributed out. There are ways, even with C3 accumulation trust, where we can manage that income tax problem. So there are ways you can do that. You make distributions out to the beneficiary will pay at their tax rate. You can accumulate, you pay at the trust rate, and now we have the ability with our documents, there's a little switch in the documents. We have a non-beneficiary party, gives a beneficiary a limited time power to take the income out, kind of like withdrawal power. And even though they never take it out, we get to pay tax at the beneficiary's rate. Takes a little bit more complicated, but we can manage that taxes. So C3 accumulation, it is definitely has the most cost and hassle to administer it, but it may be the best answer from an estate planning perspective, depending on the situation. Those two, conduit and C3, were the qualified trusts that get the standard 10-year rule and potentially the life expectancy, depending on the situation. The non-DB trusts are where you do not have an individual or qualified trust. And so what does that have? The 5-year cliff rule, if you die before the required beginning date. The required beginning date used to be 70.5, and now it's 72. Required beginning date is actually not age 72. It's April 1st, the year after you turn age 72. It's the date, the furthest away date, the first payment must be made. The first distribution must be made. That's the RBD. If you died before that date, 5-year cliff rule. You die on or after that date, you go through the ghost life expectancy, which is the participants, the now deceased participants' life expectancy as if still living. One caveat, a Roth IRA is stuck with the 5-year rule because it doesn't require any distributions during the participant's life. Since the participant isn't now required, there is no RBD for a Roth. There's no RBD for a Roth. There's no ghost life expectancy. You're stuck with the 5-year cliff. So if you have huge Roth IRAs, the non-DB trust may not be the way to go, at least not to that extent. All right, what are the pros? The pros are, depending on the age of the participant, so here's where it counts how old the participant is. If the participant, when they die, so you look at how old you or the advisor talking to you, when you think you may pass away, basically, and you look at where you are today, just looking at the odds. If you are between 72, 73, when this starts, the ghost life expectancy, so the ghost life expectancy could be longer than 10 years if you die between the RBD and about age 80. It's actually more than 10 years. So you may not better off. Now, it's not a 10-year cliff where you make nothing until the 10th or anything in between as you want. You got to take out annual distributions under the ghost life expectancy, but up till age 80. Now, most people that I would say that are our clients, the top 20%, you're doing okay. They have good access to good health care. They can exercise and all that kind of stuff. Their life expectancy is usually if you look at the average, is going to be in the 80s, mid 80s, something in there. Some go less, some go 90s, but usually mid 80s, just 50 in the 50 percentile. So you're going to be beyond this 10 years. So at 80 years old, the life expectancy starts to go down. When you hit age 90, 91, you're back to 5-year cliff. I'm sorry, not 5-year cliff, 5-year remaining life expectancy. So depending on the participant's age, and if you're married, participant or spouse, because they're both going to end up owning it at some point, or the survivor's going to end up owning it. You look at that age and say, what do you think it will be? The big one is that's okay, but the big one is, like see-through accumulation trust, you can accumulate. Conduit cannot accumulate. See-through accumulation and non-DB, you can accumulate. That's the big bonus. We get to accumulate because we want the benefits of the trust. The next one is, we do not have requirements of see-through accumulation trust. There's no requirements. We can do whatever we want. We can have any restrictions we want. We can have no restrictions. We can do all kinds of stuff for estate planning purposes. So the tax tail of the RMD rules are not wagging the estate planning dog. To me, the estate planning desires should control over the tax rules if we can help it. So you may end up with a longer the payout period. You can accumulate. We don't care about any restrictions that these other trusts have. We can do whatever we want. It has lower maintenance costs than a see-through accumulation trust. It has slightly more hassle and cost than a conduit, only because we have to do income tax planning. Because to the extent the assets are accumulated, the income tax rates could be higher. So we end up having to do a little switch to pay at the child's rate or distribute. If you do a little planning, and that planning I would consider a little bit of cost and hassle. So from a cost and hassle perspective, conduit trusts are the least hassle and cost. See-through accumulation is the worst, and non-DB is the middle. What are the cons? The cons are, if you die before the required beginning date, you're stuck to 5 years. If you die after age 80, it starts to go down below 10 years. Hit 91, 90, 91, it's about 5 years. For Roths, you're stuck with a 5-year cliff. And this is the elephant in the room on non-DB trusts. Elephant in the room. If you are still working and you have a retirement plan that you haven't rolled over into an IRA account, even if you're retired and you haven't rolled it over into an IRA account, a non-DB trust with a qualified retirement employer plan is a horrible, let me repeat, a horrible idea. Why is that? With a non-spouse beneficiary, normally you have to look to the retirement plan. You have to look to the retirement plan anyway. And the retirement plan can be more restrictive than normal tax law. And most retirement plans say that there's a full payout requirement to a non-spouse beneficiary within 1 to 3 years. That's not the law. That's in the retirement plans. And the reason it's in there is they don't want responsibility for your kids. They don't want to be responsible. The employee is gone. Their spouse is gone. They don't want anything to do with it. They want out. They want out of the risk game. In, I believe it was 2006, the government changed the law and said that if you have a retirement plan, you're allowed to roll over the retirement plan into an inherited IRA account to get all the distribution possibilities of an IRA account. Perfect. The problem is, which I did not learn until a couple months ago, is that rule only applies if you have a designated beneficiary. If you have a non-designated beneficiary, you cannot roll it over into an inherited IRA, which means you are stuck with the retirement plan's limited distribution options. It is a horrible result in many, many cases. All right, so that's the big one. We don't have much time left, so let me rip through this thing. Let's go through step 5. What are these other factors to consider? Do concerns exist with see-through accumulation trust limitations? Do you care about all this other stuff? If the answer is yes, the C3 accumulation trust limitations may just not, you may want to go another way. What type of retirement plans are involved? Well, if you have, as we talked about, a Roth IRA or employee qualified plan, non-DB trust may not be the right way to go. Are the retirement funds significant in relation to all of your wealth in amount and relation just in general to the amount of wealth? And we have had this come up a bunch. We have wealthy clients, maybe several $100,000 in IRA amounts, but compared to the rest of the wealth, it's insignificant. So you know what? Conduit trusts are fine. Where if you had not as much wealth, and that was a decent percent of your wealth, the conduit trust may not be a good answer. What are the ages of the non-spouse beneficiaries? Are they young? So you get to that whole issue about do they qualify for the eligible designated beneficiary as a child or not? Are they young? Will you get them to the age, can the trustee be there long enough to make sure that the assets are protected, those kind of things? Is it important to get the eligible designated beneficiary status? If it is, you have to go outright or a conduit. How important is to maximize the asset protection, control benefits of trust? With that one, you need to be able to accumulate, because if you can't accumulate, the trust just gets avoided. So we need to be able to accumulate. You can only accumulate with the two options: see-through accumulation that comes with all of the baggage that it has, with a non-DB trust that has the not as great distribution rules. What is the likelihood that one or more intended beneficiaries may become disabled, chronically ill? If you go that route, the see-through accumulation special trust is probably the right way to go. How important is to provide for charity? Are you okay providing for heirs for contingent beneficiaries? So that you may need to provide for charity in a different way. If you want to see through accumulation trust, you may just not be able to get around it, or you may be able to just put it in a separate trust to limit, to kind of cordon off that issue. How important it is to permit the child to have the power to change how the assets pass at their deaths if you have long-term trusts or dynasty trusts. And with see-through accumulation trust, we have to limit how much power someone has to add in other people. We can go descendants only, but to go to spouses, we have to limit them. Anyone else, you have to limit it because you don't know how old they're going to be. And remember, we have to be able to decide everyone's an individual, any possible beneficiary is an individual, and who is the oldest that could ever benefit as of the participant's date of death. Powers in the child to change happen after the participant dies, so they could never bring in someone who is older. There's always has an individual, and no one could be older. And you can't do tax planning. How important is future tax planning? Get a step up at the second spouse's death. You can't get a step up at a beneficiary's death unless if the trust is otherwise structured not to be includable in the estate tax calculation of that beneficiary, unless we give them a general power of appointment, which is a technical way to cause inclusion, and to get to step up an income tax basis. If you have a see-through accumulation, you cannot do that. How important is to minimize cost and hassle? As we went through, conduit is the simplest, the least cost and hassle. Non-DB is the middle. The see-through accumulation is the worst. Now, what can you do to get rid of the negatives of the RMD rules? You can convert from regular to Roth IRA. You can do qualified charitable distributions. And we have, in the other papers on our website, we have more explanations of all these things. But the qualified charitable distributions, you're not going to want to do this year. You'd want to if you're still working with a qualified plan, you probably want to postpone distributions. That's the one exception, starting distributions at age 72. And the last one is, if you want to this is the big one. If you want to give a charity, you can think about different ways to provide for charity. Since it's going to be taxed sooner and it has issues with it, if you are charitably inclined, this might be a great way to use those assets and provide for charity. The last one, how did the CARES Act affect? So the CARES Act came out. We have the coronavirus, horror economic situation. Government comes out with this massive CARES Act, which we're dealing with all the time now. But it had a bunch of provisions about retirement plans and the RMDs. What were the main things that it did? It got rid of, this is a huge deal, it got rid of the required minimum distributions for this tax year. Repeat, no RMDs, no distributions required from IRAs and qualified plans for this tax year. There is an exception for 457 plans. They're sponsored by a non-governmental tax entity. So a 457 plan, a tax deferred plan by charity type entity doesn't count. but the rest of them do. That's huge. If you've already taken out your requirement of distribution and you want to get it back, there may be a way to do that. They've extended the rollover period to July 15th. Normally you have 60 days to roll it over. So we still have some more time to fix that. This year may be a better year to do a Roth conversion. Normally you have to get your RMD distributed first, and then you can distribute to get a Roth. Now, since there is no RMDs, every dollar that comes out can be converted into a Roth IRA. And also, one last thing, the 10% early distribution penalty for distributions before 59.5 is waived for coronavirus hardship related distributions up to 100,000. So what does that mean? Up to $100,000 can be distributed from IRA qualified plan, from an IRA basically. And the following things happen. If you're below 59.5, it's 10% penalty in most cases. However, in this situation, if you have a defined coronavirus hardship, which is broadly defined, then even if it's a dollar, you have to go through the definition. But if you do, you take it up to $100,000 and you get to pay the tax over 3 years. And there's no 10% penalty. And you could, in lieu of paying it back or paying tax on it within 3 years, you could pay it back within 3 years. So you get basically a kind of an interest-free loan, kind of loan to yourself. You basically get the money, you get to use it, and you can put it back in. This is not intended by this act, but in theory, if you're financially okay, but you did have a defined coronavirus hardship, you take $100,000, you can convert it into a Roth IRA, and then you can either pay the tax within 3 years, by the end of 3 years, or you can take other $300,000 and put it back into the IRA account. So, for anyone who's still here and hasn't got tired of me, thanks for hanging out. If you have any questions, Allison, did anyone bring in any questions? Allison, you still there?
Yes. I'm here. Can you hear me?
Yes, I can.
Okay, sorry. I think I was muted for a while, but
Okay.
no, I don't see any questions in the chat box.
Okay.
I do have a question though that might clarify things for some people. So when you're talking about trust, there are trusts that are standalone trusts. We call them living trusts, something you create right now and that you can start funding right away. Then there are testamentary trusts, which are trusts that are within your will, and they don't get created even until you pass away and your executor probates your will and the trust gets set up. So these rules are applicable to both. Are there any differences?
Great question. Great question. All right. So the rules that we're talking about relate to testamentary trust, but let me go back and clarify one of the things that Allison said. So your primary document, your primary estate planning document is either a will, that shell is called a will, or that shell is called a revocable living trust. And inside that primary document is your actual estate plan. That's where you want your assets to go upon your death. So if a will is your plan, is your shell, inside the will it says, it might say, all to my spouse at the first death. And if my spouse is living, it goes into trust shares for my kids. We're talking about those trusts, those little sub-trusts inside that main document for the other beneficiaries or for the spouse or however you want to do it. Or that shell could be a revocable living trust, and the will just puts assets into that trust, and that's where your plan is located. And then again, you would have, it says your plan. How do you pass your assets to your spouse if you have one? If you don't have a spouse or your spouse is deceased, how does it go to the other beneficiaries? If it goes in little sub-trusts, those are the trusts that we're talking about. Does that make sense, Allison?
Yes.
It's a loaded question. Other things you think might help?
Okay, let's see. I see Aaron Carper has a question. The 401k withdrawal and payback are 3 years to pay tax, but she did not understand that those could be a conversion, but a withdrawal. I'm not sure what the question is.
Okay, so that might have been the CARES Act. Who was the question by?
Aaron Carper. She's here.
Unmute. I just unmuted you, Aaron. You want to say it?
I understand that you can take up to the 100,000 out for the purpose that you have a hardship, so you need it to live on. You either have 3 years to pay it back, or you can take the tax and pay it over 3 years. What I didn't understand, or what I didn't see included, was the fact that you could take out $100,000 from your 401k and roll it up into a Roth. I wasn't.
All right, so I'd have to go back and look to see if I know it applies to IRAs. I'm not sure about qualified plans, so it might. But the first thing you have to deal with retirement plan are the terms of the retirement plan. So unless they modify their terms, it's not possible. It would be an in-service distribution that would allow you to do it. And I think it applies, but I'm not 100%. I know it applies to IRAs. It may apply to retirement plans if they modify their plan, or it already allows in-service distributions. So what you would do is you would distribute it from the retirement plan if they allow it. Now you have it. Then the question is, can you roll it over into an IRA or roll it into a Roth IRA? And I think the answer is yes, in a rollover. I think that may be it might be a multi-step process, but I think you can get it in there.
Richard, I see one more question here from Richard Zelmer.
Okay.
If you took your required minimum distribution on January 15th of this year, is there any way to reverse it?
Okay, if you took it in January, I believe the answer is no. They came up with, I think I wrote it down in the paper. I think it was February 1st where they extended the rollover period. So if the 60 days had already passed, if it was before February 1st. So if it went in January, it's not going to work. Now, Natalie Choate, who is the godmother of this whole area of the law, who explains it to all of us, she believes that there is a chance that they're going to keep providing flexibility to fix these technical problems. So they came out with a ruling that said February 1st or forward. She thinks there's two issues. One, January 1 and forward. The other is you can only do one rollover within a rolling 12-month period of time. So if you're someone who did monthly distributions over the year, you can only do one. And if you can only do one max. And she thinks that's a horrible answer. So she thinks there's a chance that they're going to come back later and modify that. So the answer is hang tough. You can't do it now, you'll do it later. Otherwise, if you want assistance or you have questions, please call us. We're here for you. So thank you very much. This was our first Morgan & Salvo webinar, and hopefully we'll put on some more and we'll get better at it. Thank you very much. Have a good week. Stay safe.
Thank you, everyone.